There's a particular kind of silence you only find at elevation, the kind where the only sounds are wind through pine trees and the occasional hawk riding a thermal overhead. That's exactly what I was chasing when I purchased my mountain home. Not an escape from responsibility, not a way to dodge rules or live off the grid. Just peace, space, a place that finally felt like mine. What I got instead was a masterclass in HOA Overreach and a legal battle that nearly cost me everything. Let me be upfront about something. I went into this community with zero attitude about HOA rules. I'd read the CC and RS cover to cover before closing. Keep the property maintained? Done. Respect your neighbors? Obviously. Follow community guidelines? Absolutely. These weren't burdens. They were the baseline agreement that made a private mountain community worth living in. I had no problem with any of it. The problem arose when the HOA decided it had a problem with me. It started subtly, the way these things usually do. A notice arrived claiming I had unpaid fines for rule violations. Then another. According to the board, I had ignored multiple warnings and was in serious noncompliance. The notices were vague, referencing issues that were either already resolved or never clearly explained in the first place. I did what any reasonable homeowner would do. I responded in writing and formally requested the supporting documentation, the specific complaints, the dates, the official records that justified each fine. What I got back wasn't documentation. It was escalation. The HOA president showed up at my door with a folder of papers and a tone that made it clear she considered the matter settled. She cited the board's authority to enforce community rules and implied that my best option was simply to pay and move on. I asked her one question. Can you show me the exact records proving these violations? The conversation shifted immediately. She wasn't prepared for that question, which told me everything I needed to know. I hired a property dispute attorney within the week. Together, we went through every notice, every letter, and every piece of correspondence the HOA had sent. The deeper we looked, the more the case started unraveling on their end. Several notices were missing critical details required by the community's own governing documents. Certain procedures hadn't been followed in the sequence the CC and RS mandated, and in multiple instances, the board had moved forward with enforcement decisions without giving me a documented opportunity to respond. A basic due process requirement that even private HOAs are generally bound to follow. My attorney put plainly, an HOA can absolutely create and enforce rules, but those rules must be applied through proper procedures, with proper documentation, and with proper notice. We decided is not a legal standard. We documented, notified, and followed our own bylaws is, while we built our case. The board continued pressing forward, apparently confident that I'd fold under financial pressure. They began discussing more serious action against the property, the kind of language that's designed to make homeowners panic and comply without asking further questions. I didn't panic. I documented. Every development was photographed. Every communication was logged. Every timeline was reconstructed with precision. When the full picture came together, what we had wasn't just a homeowner defending against fines. It was a documented record of procedural failures at nearly every stage of the HOA's enforcement process. Steps had been skipped. Verification hadn't been completed. The board had prioritized speed over accuracy and assumed their authority alone was sufficient justification for their actions. It wasn't. As our legal response took shape, the HOA's confidence visibly eroded. Board members who had been vocal supporters of the enforcement action started going quiet. Other residents in the community began asking their own questions. Because when word got out that the process might not have been handled correctly, people started wondering whether similar mistakes could affect their properties too. That's the thing about procedural failures in an HOA context. They don't just affect the target. They undermine trust in the entire system. The HOA president, who had arrived at my door with such certainty just months earlier, was now fielding uncomfortable questions at community meetings she had called to talk about something else entirely. Formal discussions eventually began between both parties. I want to be clear about my goal going into those conversations. I wasn't looking for revenge, a financial windfall, or to dismantle the HOA. I wanted what I had wanted from day one. Accurate information, fair process, and decisions made on facts rather than assumptions. I had purchased that mountain home legally. maintain it responsibly, and engage with every request in good faith. I simply expected the same in return. The resolution confirmed what our legal review had found. The HOA had made significant procedural errors throughout the enforcement process. The documentation hadn't supported the claims. The process hadn't followed the community's own rules. Corrections were made, records were revised, and the board undertook a formal review of how future disputes would be handled, with clearer documentation requirements and a more structured notification process before any enforcement action moved forward. My mountain mansion is still mine. The views haven't changed. The silence I came here for is still there every morning when I step onto the deck with a cup of coffee and watch the light come over the ridge. But I'd be lying if I said the experience didn't change something. I'm a more careful homeowner now, not more fearful, but more informed. I know my governing documents the way I know my property lines. I keep records of everything. And I no longer assume that the people in authority over a community have necessarily done the work to justify that authority. Here's the hard truth about HOA disputes that most people don't realize until they're already in one. The board's confidence is not the same as the board's correctness. An HOA can act decisively and still be procedurally wrong. They can send letter after letter, hold meeting after meeting, and cite bylaw after bylaw, and still fail to meet the basic standards their own governing documents require. When that happens, documentation is your defense. An attorney who knows property law is your translator. And the willingness to ask, "Show me the proof," calmly in writing on the record, is often the single most powerful move a homeowner can make. Don't assume the people with clipboards have done their homework. Sometimes the biggest mistakes happen not because someone had bad intentions, but because they acted before they had the full story. And sometimes a mountain mansion and the peace you worked your whole life for is worth fighting to keep. Enjoyed this story? Hit like, subscribe, and turn on notifications. New HOA stories every week. Drop a comment below. Have you ever faced HOA overreach? Where are you watching from today?